diverts certain offenders. If you're eligible for Prop 36, instead of going to prison or jail, you go to treatment. So it might free up space in that program, which could be used for other offenders since the resources are limited right now again. And another effect that it would have would be on the medical marijuana program, which was established in 2003 by the legislature, which set up a patient registry for medical marijuana patients so that they could have an ID card. And because marijuana would be legal, it's likely some people would no longer participate in the medical marijuana program. However, the program is supported entirely by fee revenue, so you'd sort of reduce both the fee revenue and the cost of the program. On the last page of the handout, we talk about some of the potential new revenues from legalizing marijuana. Again, there's a couple of caveats, as I mentioned before. We don't know how the federal government would continue to enforce its own marijuana laws. We also, there's not a lot of good data on the current price of marijuana, what would happen to the price if it were legalized. There's not good data on current consumption of marijuana or what would happen to consumption if marijuana were legalized. So there's quite a few caveats there. But basically, in our analysis, we found that state and local governments could potentially realize first new excise tax revenues. And just for an example, we estimate that an excise tax of $50 per ounce on marijuana could potentially generate a couple $100 million annually. In addition to that, the state and local governments could also realize new sales tax revenue. The state actually currently collects sales tax revenue on medical marijuana sales, and if marijuana were produced commercially beyond just for medicinal uses, it would increase sales tax revenue. And finally, the state could realize additional income tax revenue to the extent that legalizing marijuana led to a new industry and created new jobs in that nature. It would lead to increased income taxes. And that concludes my testimony, and I'd be happy to answer any questions.
All right, thank you very much. And I do have some clarifying questions and also some points. One of the things I wanted to ask you was that in terms of incarceration, do you have a ballpark about how many people are incarcerated for possession and sale of, or cultivation or manufacturing of marijuana?
Yes, so currently there are about 1,500 individuals in state prison on marijuana offenses, and the breakdown of that is about 850 are in state prison under marijuana possession for sale, about 470 for sale of marijuana, and about 120 for other marijuana offenses, which would mostly be cultivation.
What's the current cost of incarceration for an inmate?
So it costs the state on our, there's two different costs that we use for state prisons. One, which you've probably heard, is the about $50,000 per inmate per year. That's sort of the full average cost. But when we're talking about incremental changes in the inmate population, smaller numbers such as this, we use a marginal cost number, which is about $23,000 a year. And that's just because the prisons are overcrowded right now. So each person that you're adding or subtracting isn't really necessarily resulting in the full cost. So it's about $23,000 a year for each of those inmates.
And then on page 4 of your handout, you posit that legalized marijuana will have a fiscal effect on publicly funded substance abuse treatment programs, including drug court. Well, doesn't it make sense that there would be a cost savings to drug court since there would be no pending criminal charges?
Yeah, the only point that we were making is that right now the amount of resources for drug courts or Prop 36 programs is limited. So if marijuana offenders were not sort of in drug courts or in Prop 36, it would free up that money to be spent on other offenders.
And then in terms of, you know, if there were a state tax or fee on marijuana sales, do you feel there'd be an impact on the overall state budget, and would that serve to offset some of our budget pressures?
Yeah, correct. As I mentioned, you know, we are estimating that there would be, you know, it would depend on the tax rate that was set, if there was an excise tax and stuff, but, you know, conceivably there could be several hundreds of millions of dollars which would outweigh any of the probable increase of costs for substance abuse
And
treatment.
then on the medical marijuana front, how did federal prosecution affect the fiscal implications of 215? And could we draw a comparison?
Well, the federal government continued to prosecute, although marijuana, medical marijuana dispensaries did continue to operate. Now, probably there would have been more of them if the federal government had not been enforcing their laws during that period. And we don't know how aggressively the federal government would enforce their laws. I think with medical marijuana, while they did take a fairly hard stance, they could have taken an even harder stance. And we don't really know if it were legalized
And a
broadly.
different administration, so.
And a different administration.
But if counties were able to incarcerate more appropriate criminals, wouldn't that reduce the pretrial release or post-correction release? Wouldn't that also have some savings?
From the county?
Yeah.
Yes. Yeah.
And I was thinking about the medical marijuana. If anything, if we did legalize it, as you refer to, counties would not have to spend hours and money drafting regulations and for medical marijuana as an exception, et cetera. So there should be some savings there, I would imagine.
It's possible. I think it would also depend on whether, so for instance, some of the initiatives that we've analyzed have specifically said medical marijuana would not be taxed. Therefore, you would think that people who need it for medicinal purposes would probably still want to use it for medicinal purposes, and since Prop 215 is still the law,
Yeah, I get it.
it's hard to say it would disappear entirely, but it could be it could help.
To be determined.
Yeah.
All right. Colleagues, any questions for Mr. Golowatsky before we go on to the Board of Equalization? All right, Mr. Warren?
Actually, I'm here just to support Paul. We helped with the fiscal estimates on the taxes and consumption, so
Okay.
Here to just help with questions.
All right. Just a quickie then. How did you arrive at the assumption that, because I think I heard something different, that would increase, that consumption would increase 40% upon legalization, and did you base your fiscal estimates on that assumption of the 40%?
No, there's a lot of different estimates about what consumption is, and it's uncertain as to how consumption would change as it became legalized. So these are all the kind of things that we wrestle with in trying to come up with an estimate.
Yeah. Okay, thank you very much. We're going to go to the Board of Equalization. I think my previous question probably would be more appropriate for, it is Mr. Robert Ingenito and Lynn Bartolo from the California Board of Equalization.
Yes.
Welcome.
Good morning, Mr. Chair and members. I am Robert Ingenito, Chief of Research and Statistics for the Board's Research and Statistics section. Before I highlight the assumptions and the methodology that we use to estimate the amount of revenue that legalization of marijuana and a subsequent taxation might generate, I thought it might be helpful for us to give you a brief overview of the Board's tax administration and revenue estimation activities. The Board currently collects taxes and fees that provide roughly 1/3 of annual revenue for the state government, as well as a significant portion of funding for cities, counties, special districts, and other local jurisdictions. BOE administered taxes and fees generated about $53 billion in fiscal year 2007-2008. And the Board administers the state's sales and use tax and about nearly 24 of its special taxes, including its fuel taxes, its cigarette taxes, and its tobacco taxes. Now, the Board's Research and Statistics section, which I oversee, prepares revenue estimates on a regular basis as part of our regular workload. More generally, the Board staff monitors legislation that would impact the tax programs that the Board administers, as well as bills that are of interest to our 5 elected Board members. Thus far in 2009, we've prepared over 100 formal and informal revenue estimates for a variety of stakeholders, including the Legislative Analyst's Office, the Department of Finance, our own Board members, the Commission on the 21st Century Economy, several other stakeholders as well. So the point I'd like to leave with the committee is, even though this is the first time we've been asked to look at what taxation and legalization of marijuana might generate in terms of revenue, the revenue estimation process is something that we're familiar with and do on a regular basis. So when we were asked to actually do this drill and figure out what the revenue estimate might look like, we used the same methodology that we use to model increases in the state's tobacco taxes or its alcohol taxes. So that's the basic framework that I'm going to lay out for you. And hopefully I'll answer the questions that you have along the way. If not, please feel free to stop me. There's going to be a lot of numbers involved, and I apologize for that.
Let me respectfully interrupt you. I want to acknowledge the presence of our Vice Chair, Assemblymember Hagman. And we made a few opening remarks about the direction of the hearing, the number of panels we're going to have, and then public comment. And, you know, this is getting people's point of view, more or less, to educate us for our committee hearings in January. So you're welcome to make any remarks, or if you want to wait to the presentation, it's up to you.
Well, thank you, Mr. Chairman, and I apologize, Aaron. The two committee hearings I have this month happen to be at the same time and two different floors, so, and both very good and interesting issues. So I'm looking forward to being educated today. I do have a lot of concerns, but hopefully we'll be addressing some of them. Thank you.
Okay, thank you, sir. Mr. Nunito.
I'm sure the one final introductory mark I'd like to lay out before we get into the specifics of the numbers is that we concur with the analyst's office regarding the significant amount of what's unknown in the world that we need to operate to make these revenue estimates. Specifically, as I go through my presentation, there's going to be 5 key assumptions that we need to make. And if those variables turn out to be higher or lower than what we assume, the revenue estimate would commensurately be higher or lower. So there's a lot that we don't know, but nevertheless, what my staff tried to do was to review the literature that's available, both government sources, other sources, and just make the best assumptions we can make to provide you a rough order of magnitude as to what the legalization and taxation could generate. So what we're going to basically lay out for you is a 6-step process. Here we go. Step number 1 is a step that we've actually never had to do because it's not one that's involved in the case of cigarette revenue estimation or alcohol revenue estimation. It's to determine the size of the market now, what the consumption of marijuana currently looks like and what its price looks like. And as our colleagues at the LAO just pointed out, there's no hard evidence that's credible that lays this out. So we had to determine this from the best available information. And what we chose to do was we looked at a federal survey on federal drug usage. It's the National Drug Survey on Drug Use and Health, published by the Substance Abuse and Mental Health Services Administration inside the U.S. Health and Human Services Agency. This is an annual survey that's done. The sample size is about 65,000 respondents, about 3,600, I think it is, of which are in California. And they ask a variety of questions on substance abuse, many of which pertain to marijuana. The survey, again, is conducted annually, and what it said was, in 2007, about 2.9 million Californians aged 18 and up reported that they'd used marijuana sometime within the past 12 months. And 1.7 of those respondents used marijuana within the last month. So just to clarify, 2.9 million within the last year, 1.7 within the last month. Now, in doing this revenue estimation drill, we assumed that the legalization age would be 21, not 18. And the data as published in the conventional tables by the feds don't actually have numbers on federal usage of age 21 and up. We actually have a request in with the federal survey makers to get that number. And for the time being, we've estimated that 2.4 million Californians aged 21 and up have used marijuana sometime in 2007. Okay? But just knowing the total number of users doesn't help us because we also need to know the frequency, as again was pointed out by the LAO. We need to know how many of those 2.4 million 18 and up Californians use it on a daily basis, how many use it less sporadically, how many use it more sporadically. And unfortunately here, the survey doesn't help us much because the survey only gives respondents 3 choices when it comes to frequency. Within the last month, between 2 months and 12 months ago, and then more than 12 months ago. So what we did actually was 2 things. Number 1, the same survey releases from time to time an estimate of national daily users of marijuana. The last time they did it was in 2003. And just using some proportional estimates, we've determined that about 400,000 or so Californians use it on a daily basis. But that still leaves the more frequent users and the less frequent users to try to estimate. And to do that, we actually relied on a United Nations report on drug usage from 2006. What the UN reports is 45% of users consume marijuana on average 4 times a year, so they're an occasional category according to the UN data. 41% of users consume it roughly 100 times per year, 9% consume it on a daily basis, and 4% consume it multiple times per day. Now, when we looked at the federal survey on daily usage and the UN numbers, the proportions were pretty close. So what we opted to do was just to use the UN numbers as a proxy for California, assume that California usage ties to that of the rest of the world, and that's how we got our distribution of use by frequency. Okay, and in doing that, we ultimately came to an assumption that about 1 million pounds, or 16 million ounces, of marijuana is consumed annually. So if you actually take the 2.4 million Californians that use it, allocate it to the different cells, and run the math, that's the number that we get. Okay? So the second step in the process is to determine what would happen if the consumption of marijuana were legalized, what that would do to the price. And here we just relied on standard microeconomic convention, which says that if the price of any good goes down, its consumption was going to go up. So we speculate here using, again, microeconomic supply-demand analysis, that if marijuana were legalized, the supply would increase, and that would in turn put a downward pressure on price. We reviewed the literature and saw estimates that suggested that the legalization of marijuana would reduce the price by 50%, and that's the number that we put into our framework. Step 3 then is to determine what the consumer response would be to that decline in price. So here we treated marijuana as if it's any other good. As the price of the good goes down, consumption is forecasted to go up. So we used basically the same data that we would use to estimate the response of cigarette smokers to a change in price. Given that we didn't have anything specific for marijuana, we used the same consumer response that we've seen in the data over the years for cigarettes. Okay. So under this assumption, when you run the math, you get, after legalization with the lower price and the higher consumption, new consumption would rise from the 16 million ounces to 22.4 million. That's an increase of 40%. That's how we got it. Okay? But the next step of the process, step 4, is to introduce the excise tax. So far, all we've seen is a response in consumption is in response to its legalization. Now, the impact of the tax would work the other way. The tax would increase the price, so microeconomic convention would say that the consumption would go down somewhat. So here, we've calculated, just using a hypothetical $50 per ounce price, we've again running the math using the same response that cigarette smokers would do, same exact elasticity calculation is a technical term. We have calculated that the consumption would be reduced by 11%. So now we've gone from 22.4 million ounces down to 19.8. So we're still 3.8 million ounces higher than the initial estimate that we've come up with. So now we've arrived at 19.8 million ounces consumed after marijuana has been both legalized and taxed. You multiply 19.8 million times the $50 tax rate, and you get our estimate of $990 million in excise tax revenues. So that's how we got roughly $1 billion in excise tax revenues. Okay. But the sixth and final step is to determine what, if any, sales tax revenue would also be generated. And here's where it gets more tricky, because under current law, retail sales of marijuana would be subject to tax just like most other goods. But what we don't know is we have no information on consumer spending patterns, and we don't know if the new consumption of marijuana would come at the expense of goods that are being taxed currently or not. So if, for instance, money that was being spent on services which are not taxed was suddenly redirected toward purchase of marijuana, which is taxed, then new sales tax money would be generated. If we're just switching from some other good that's currently taxed over to marijuana, there would be no new sales tax generated. We don't really have data to make that determination, but we've just taken the two bounds, and if all the money that is now being spent on marijuana was not being spent on taxable goods before, there'd be an additional $392 million raised in sales tax revenue. That's both state and local, mind you. So the general fund portion of that would be $263 million. So we basically have a range of about $1 billion to $1.4 billion as a consequence of the policy. So just to conclude, again, this is an imperfect exercise. We've had to make assumptions. We've had to assume, Californians behave in some ways the same as other folks in the nation, and in one case around the world, but it's the best data that's available to sort of put a hard number on this.
I really appreciate it. I know that there's this is new territory, so I appreciate your methodology. I was curious, do you know what methodology the Federal Survey and the UN used in gathering Did they call people? Did they?
I don't know this for sure, but it's my understanding that the federal government survey actually is one that's done by survey takers. I know I was looking at the survey questionnaire actually, and one of the very first questions right out of the box is, have you ever used marijuana? The second question basically says something to the effect of, this is important for research purposes. I'm going to ask the question again. Are you sure you're right about your question
Well,
to answer
I would
one?
imagine there's some fear because it is illegal.
I would presume so.
Who you're going to vote for, and then when you go into the.
Right.
And then, assuming the federal government continues to prosecute for use and possession, cultivation, would that affect the calculations?
Yes, our assumptions
Of
are
tax
that we
revenue.
could, this operates in a world where the federal government would not impede our activities.
Thank you. I was trying to follow your numbers.
Sure.
And what was the use per day or use per week per, how'd you figure that out again? I know 2.4 million people in California, but what was the frequency? I'm just trying to figure out the habit of the cost with $600 an ounce, whatever it is.
Sure. The numbers that we tied to that were from the United Nations report were that 45% use it roughly 4 times per year.
And 4 times a year, and
Yes.
how much is the typical usage? I don't know.
Typical
So-
usage?
Yeah, so
The literature
people are
basically
buying 1
says
ounce or buying 10 per
1
year.
gram per use is what we've seen in the research. And then 41% of users consume it roughly 100 times per year.
So 100 grams. Okay.
We can provide you some math
The
tables if
matrix
that's helpful.
Thank you, Mr. Chair. It seems that the BOE and the LAO's office, in looking at surveys to determine cost and usage, and I guess the United Nations use of surveys as well, are there other areas, I mean, there are other areas in the world that have legalized marijuana and use and sale. Is there data available from those, changes from pre-legalization to post-legalization to look at consumption, look at revenues and taxes? Has that been looked at all?
We've reviewed some of those studies. They conflict in a few of the cases. More than anything else, we just assume that, well, what's the best way to put this? Now, in reviewing the data coming from around the world, I mean, we looked at price declines when legalization happened, I think in Australia, for instance, and some places in Europe. And the numbers that we looked at when we ultimately made our determination were in the ballpark, in the range of all those. As far as, I'm sorry, can you repeat the question?
Well, no, it's just, in other places, the Netherlands and where we've seen, use and legalization, what have been the changing in terms of buying habits and use, taxes? Has use increased in the percentages that you've looked at here or indicated, and has the price declined at the rate? And what have been, and then this will go to other questions, I'm looking for societal problems that have been created by that, if there have been any.
Well, I can't.
And that's not your area, I know.
Yeah, I can't speak for
Looking
societal problems, but
fiscal issues.
I'd have to get back to you, but I believe our changes are in the ballpark of what other countries have experienced.
And you base that on data that has been collected from those other countries?
Yes.
And an analysis has been done? Okay, thank you.
Most of the most of the studies from other jurisdictions involve decriminalization of marijuana, which basically means it's not legalized. It's just people aren't being incarcerated necessarily for it, but it's not a legal regulatory system. So really the only place that would come close to actually legalizing marijuana is the Netherlands. And there were several studies done to determine what happened to consumption and prices afterwards, and a lot of them do conflict, so it's kind of difficult to see what happened. There were some that found that use had gone up after sort of their legalization, but it was sort of hard to untangle, well, was this more people using it casually, or did it actually lead to an increase in people with a serious problem? But that was the only case that we really uncovered, because the other examples involved decriminalization, which was kind of different than what's being discussed
I was
here.
curious as to the comparison with smoking. I mean, were there statistics? Did smoking, did smoking go up when the price went down, and did we take into account a previous history? Was a person a smoker or not? Some of those things are variables that probably would affect in the same way, I would imagine. Yeah. Mr. Hagman, did you?
Again, following up with some questions. So we did this a good little project to figure out the potential tax and income, sales tax. But isn't this kind of, if the federal government does not legalize it, then how can we force somebody to pay a tax or fee and be self-incriminating on a federal law? So, I mean, you really can't accept any taxes or fees based on the federal laws unless the federal law changes, even if we change our own here in the state. Or can you explain how that would work? I don't want to be self-incriminating by paying something that's considered illegal in one sense and legal on the other.
Right.
Yeah, well, currently you pay the tax anyway, and we are going to have our next panel is going to deal with the constitutionality and what if the federal law preempts, what are our options, et cetera, if that would satisfy you when we get to that panel. Okay?
It's a very good question, though, because
Sure.
how legal is it is a really important function, a factor about how, in practice, legalization in California would work. What the feds do they just turn a blind eye? Do they continue to do raids of pot farms? So there's different levels of legalization and how the feds would interpret what we do. So, for instance, if it were legal, if the Fed said, we changed our mind, it's legal in the country, right? All the pot farms could become legal farms, right? Pay income tax.
Well, through a process. I mean, if it's regulated.
Sure, okay,
Yeah.
if it's regulated, but they could become legitimate businesses where now they're kind of hidden. So, the variations of what it is, how the feds would respond to what we do are extremely important in understanding what the ramifications are for revenues and for a
However,
variety of the
California could be out of the gate early on this, and that if there in fact there is a change in federal law. But again, we will get into that with our next panel. So I just wanted to thank you very much for the work that you've done. We really appreciate it. And our next panel is going to deal with the constitutional issues confronting the legalization of marijuana. And we have a staff attorney from the Drug Policy Network, and then we have a counsel from the American Civil Liberties Union, and then we have legal counsel, California Peace Officers Association.
Morning.
All right, we wanted to touch upon some of the constitutional issues. We wanted to discuss some of the constitutional issues that would come up in and around legalization of marijuana. And perhaps, Ms. Todd, you could start first.
Great, thank you. Good morning, Mr. Chair and members of the committee. My name's Tamara Todd. I'm a staff attorney with the Drug Policy Alliance Network Office of Legal Affairs. I'm here this morning with Alan Hopper. Mr. Hopper is the litigation director of the ACLU Drug Law Reform Project. Thank you very much for having us here today to discuss the constitutional issues raised by the proposed legalization of marijuana in the state of California. Mr. Hopper and I each have a prepared statement, but we hope to leave time for questions at the conclusion. I will first provide a roadmap of the constitutional issues and briefly discuss the principles of federalism. The Constitution addresses the issue of federalism in various places. The Supremacy Clause establishes that federal law is supreme over state law when they conflict. The Commerce Clause grants power to the federal government to regulate interstate commerce. And the 10th Amendment reserves all other powers to the state except those that are specifically designated to the federal government. Mr. Hopper will discuss federal preemption more specifically in the context of the Controlled Substances Act and delve more deeply into the 10th Amendment issue. But before I get to the various constitutional provisions, there's one overriding point that should not get lost in a complicated discussion about constitutional law, and that is this. There's absolutely nothing in the United States Constitution that requires the state of California to criminalize anything under state law. If the state of California wanted tomorrow, it could repeal its entire criminal code. Under our system of government, states decide state law. There are limits to what a state can criminalize. For example, the state could not make it illegal for African Americans to own property. But nothing in the Constitution requires that the state criminalize anything. If California decides to legalize marijuana, there's nothing in the Constitution that stands in its way. As you all know, the Constitution establishes a system of dual sovereignty. The federal government creates and enforces federal law in the areas expressly granted to it in the Constitution, and the state governments create and enforce state law. As I mentioned, under the Supremacy Clause, federal law is supreme, and when the two conflict, federal law is upheld. Mr. Hopper will go into more detail about this in his discussion of preemption.
Let me just clarify.
Yeah.
If the courts determine a statute aimed at legalizing marijuana is in violation of the Supremacy Clause, then what effect does that have on that statute? It's preempted? Is that what you're saying?
If the court finds that it's preempted by federal law, then it would be. As Mr. Hopper is going to explain, the Controlled Substances Act allows states to create their own criminal laws when it comes to drug and their own drug enforcement laws. The Controlled Substances Act does not say that federal law preempts state law, and he's going to get into a detailed discussion about why that's so in his remarks. One power that is expressly granted to the federal government is the power to regulate interstate commerce under the Commerce Clause. While the scope of this power has been subject to much litigation and academic debate, it is interpreted broadly and allows the federal government to regulate in areas that have traditionally been considered the province of the states, such as criminal law. The power is so broad that it allows the federal government to enact federal laws criminalizing largely intrastate possession, cultivation, and sale of marijuana, even if those activities are legal under state law. This is the case with medical marijuana. And this was decided by the Supreme Court in 2005 in Gonzalez versus Raich. However, the Raich case only addresses the federal government's authority to enact federal law. It in no way infringes on the state's right to enact or not enact state law. The decision did not invalidate any state laws that legalize and regulate marijuana for certain categories of people. The decision about what state marijuana laws should be has and always has been up to the state. In making the decision about what their laws should be, states do not have to agree with federal law or policy. They can chart their own course. The Supreme Court made clear in 1997 in Prince v. United States that the federal government may not compel state law enforcement to enforce federal law, and they may not issue directives to states requiring that the states address certain problems or certain issues. The state does not have to march in lockstep with the federal government on policy issues, on drug policy. The result of this is that throughout history, different states and the federal government have had different marijuana laws. And in fact, for most of American history, growing and using marijuana was legal under federal law and under the laws of the individual states. Currently, the laws continue to differ. Under federal law, simple possession of marijuana for personal use is a misdemeanor, punishable by up to a year in federal prison and a $1,000 fine. In California, possession of up to an ounce is only punishable by a fine. In some states, it's an infraction. In Massachusetts, it's a civil violation. The amounts vary, the penalties vary. Each state can treat marijuana as it sees fit. Indeed, that's what the framers of our Constitution intended when they created our dual system of government. One of the most important goals of federalism is, in fact, to foster innovation by allowing states to serve as laboratories of experimentation of public policy. Dispersing power to the states encourages the evolution of ideas that can help advance an issue nationally. Justice Brandeis explained this more than 70 years ago when he famously wrote, "It is one of the happy incidents of our federal system that a single courageous state may, if its citizens choose, serve as a laboratory, and try novel social and economic experiments without risk to the rest of the country. You see this happening in the context of drug policy and the context of other areas as well, such as healthcare, where different states are adopting different policies, and people look around the country to see what works and what doesn't before they decide what to implement for themselves. This concept is also embraced by the current administration. In a memo this year, President Obama, on the issue of federalism and preemption, wrote, "Executive departments and agencies should be mindful that in our federal system, the citizens of the several states have distinctive circumstances and values, and that in many instances it's appropriate for them to apply to themselves the rules and principles that reflect those circumstances and values." This statement indicates that the current administration respects and embraces a state's right to chart its own course when it comes to public policy. This value is also reflected in the memo that was referenced by the earlier panel from the Department of Justice last week, requesting that federal law enforcement no longer enforce federal law against those who are complying with state medical marijuana laws. This approach will allow for states to enact, new states to enact novel and creative laws without fear of interference from the federal government. In fact, medical marijuana is a perfect example of the states acting as laboratories. Several states currently legalize and regulate marijuana under certain circumstances. These state laws differ in their details, but they all legalize conduct that is illegal under federal law. In 1996, many people said the legalization of medical marijuana was impossible because of federal preemption. Now, 13 years later, 13 states have experimented with different forms of legalization and regulation. And now it appears that those policies are going to be respected by the federal government. Whatever you think of the merits of these medical marijuana laws, they serve as testaments to the wisdom of our federalist system. The public policy decisions that led to the adoption of these laws in the 13 states will rise or fall on their merits, which is exactly what Justice Brandeis meant when he referred to laboratories of social and economic experiment. All this boils down to the point I made at the onset. The federal government may criminalize marijuana, but it cannot force the state to criminalize marijuana or force the state to enforce federal law. States are free to serve as laboratories, to enact new and innovative marijuana laws, and to explore whether there is, in fact, a better way. Mr. Hopper?
Thank you, Tamar, and thank you for having me here. As Ms. Todd mentioned, I'm the litigation director for the ACLU's Drug Law Reform Project, and that's a special component of the legal department of the National ACLU. In that role, I've studied and litigated the intersection between federal statutory law, constitutional law, and state law, most recently in the context of California's medical marijuana laws. And I'm intending to pick up where Ms. Todd left off and provide a little bit more detail about the contours of doctrine of federal preemption, 10th Amendment, and other things. But I have a prepared statement of about 7 or 8 minutes, but I'm happy to deviate from that and answer your questions.
I was just thinking about the interstate commerce law versus the Compassionate Use Act was held to be in violation of the interstate commerce law. But is that still valid in the state of California?
Yeah, let me back up for just a moment. And you're talking about the Raich case. Yeah. And the U.S. Supreme Court considered, and importantly, though, what was being considered was not the validity or not of the state medical marijuana law, but rather whether anything about that state law, California state law, precluded the federal government from enforcing its own laws. What had happened in the Raich case is that law enforcement went to the home of Angel Raich and her co-plaintiff Diane Monson, and it was federal law enforcement agents who were enforcing federal law. And so under the Interstate Commerce Clause, said the U.S. Supreme Court, this is clearly an area in which Congress has the ability, the authority to regulate. And so there can be federal laws, and they can be enforced even in states that have contrary or inconsistent laws. But what the court did not do, importantly, is say that California's medical marijuana laws were somehow invalid or preempted because of the contrary federal law. And that's really the important distinction here.
Well, I was thinking of in San Diego, a normal. They've concluded that this thing about it's called positive conflict.
Yes.
Yeah. How does that? Would that still be invalidated?
What happened in the in San Diego case is a nice example, and there is actually, I think, the decision from the Court of Appeals in that case is in your binder of materials, and that's a case that that I along with other lawyers in my office and other offices litigated. The question that was raised by the County of San Diego in that litigation that had enormous implications if the county were right, was that exactly what we were just talking about that was not addressed in the Raich case. It said the counties, look, federal law makes any use of marijuana illegal. How can it be that state law allows that same use? The state laws must be invalid. They're preempted. And the way preemption works, as you asked it with your question to Ms. Todd, Mr. Amiano, about how would the law be struck down? Basically, the supremacy clause of the U.S. Constitution says that federal law is supreme, and notwithstanding any contrary state laws. But what that means is that Congress, where it has the authority to legislate, as it does with drug laws under the Commerce Clause, Congress can, if it so chooses, write federal law in such a way as to occupy the field and not allow states to regulate at all. Or Congress can say, states, you may regulate, but here are some restrictions on how you can do it. It has to be at least as restrictive or permissive as federal law. Congress could have done that with the Controlled Substances Act, but did not. And this notion of positive conflict comes from in the context that we're talking about, comes from the specific language of the Controlled Substances Act, which I think is also a part of your materials. Section 903, 21 U.S.C. Section 903 of the Controlled Substances Act is an anti-preemption clause. It reads that only those laws that are in positive conflict, only state laws that are in positive conflict with federal law, such that, quote, the two cannot consistently stand together, unquote, will be preempted. And those words are important, positive conflict. Those have been interpreted by the Supreme Court.
That's what I was wondering. So would it be possible to craft legislation that would legalize but not be in positive conflict?
Absolutely. And I think that where you see that is and again, the prime analogy to our situation today and the topic that we're talking about is the medical marijuana laws here and in 13 other states now. And let me give you an example. What positive conflict means, the federal courts have said, positive conflict means that state law requires an act that is itself in violation of federal law. That is a positive conflict. In that kind of a clash, federal law would control, the state law would be invalid. So if California, for example, California's medical marijuana law required pharmacies to stock marijuana and to provide it to patients who showed a valid card or a script from their doctor, that would be a positive conflict because a pharmacy stocking marijuana would be a violation of federal law. A state law that required a pharmacy to do that would require an act that violated federal law. That would be a positive conflict. But short of that, what's been done with the California's medical marijuana laws, what could be done with a tax and regulate system of marijuana for non-medical contexts in the state, is the removal of state criminal penalties. The state can clearly do that, as Ms. Todd was explaining. And the sort of foundation, the source of that authority is the 10th Amendment. The federal government can't require California to leave on its books any current laws about prohibiting marijuana, can't force California to enact new laws, can't force California to help it enforce its federal laws. That's the fundamental 10th Amendment protection that the state has.
What about the distinction, and I think it's an important one, between legalization and decriminalization? I know for some people that's a confusing concept, so maybe you could.
It's confusing for me as well, and that's because as for as many people as use those terms, you could probably, if you push them, get that many different definitions about what they're talking about. So legalization versus decriminalization is really semantics. As I understand the proposals, and I didn't come prepared today to go step by step through your proposed legislation. I haven't reviewed it that carefully, but as I understand it, the proposal would remove criminal penalties from some, but not all, marijuana use. That folks who were not complying with the regulations, who were cultivating more than they were permitted, who were selling without a license, I'm presuming would still be in violation of the law. So when you say legalize as opposed to decriminalization, some people think that you're talking about removing all state interference at all versus, imposing some sort of regulatory system. But either one of those is permissible and wouldn't be preempted under federal law. And it, again, goes back, if you think about a tax and regulate system as one in which the state continues to impose its, to use its authority to impose regulatory framework over who can or can't engage in this activity. It's really, you think about it as a spectrum. And at one end is everybody who engages in this activity will be sent to prison. And at the other end is, the state doesn't care, has nothing to say about it. And anywhere along that line is the state exercising its sovereign right to remove some degrees of restriction and criminalization.
Thank you, Mr. Chairman. I guess I'm semi-familiar with some of the laws we have in the California state. I'm not as quite familiar with federal laws as far as it comes to possession, use, sales, transportation, those type of things. In the vacuum, so maybe you could review a little bit of that for me, but also in the vacuum, let's say we decide we decriminalize, we take out all the penal code sections regarding to marijuana here, okay, and just take that off the books. The federal laws still stay in place. So we're delegalizing or criminalizing the California law, but the federal law will still stand impact. And technically, doesn't law enforcement supposed to enforce all laws in the book, regardless if it's federal or state, or can they choose not to? And does the federal law enforcement still have the right to come prosecute? So that part would still be illegal in their mind. So basically, it's like if and our city council or whatever, we decided way back when to not say, look, we don't have time, don't write jaywalking tickets. That's kind of decriminalized. It's still on the books, and if you got caught, you still get the ticket, but if we're not going to enforce it. But that person at any time can change the policy. So if we have a friendly president today that says we don't want the feds to prosecute on these smaller things, but we get a new president in 3 years, that could totally, and keep the same federal law. Now, do you start a database with people going up and buying stuff or whatever? Can A, retroactive go after them? B, was that identify them? All these different issues are there when it has that conflict. So you may get out of sight, out of mind. California can do what you want right now, but in 3 years, what happens? Or 8 years, what happens when you get new different focus on what's going on? So just some of those things. The federal laws, I'm a little more gray on.
Yeah, no, absolutely. And to be clear, and I understand that some of the later panels will be discussing sort of the practical implications and workability of this kind of a system. And I think it's, and as I understood my job today, and I think it's important to keep the distinction in mind, is to talk about the constitutionality. Would a system like this be struck down by the courts right out of the gate because it is preempted under the Supremacy Clause of the Constitution? I think absolutely not. But yes, exactly, you're exactly right. The federal government continues to be able to enforce its own laws, and that's what we see now in California having happened with varying degrees of intensity with the medical marijuana laws that were passed some time ago. I do think, though, that this may be a historic opening in that the federal administration that we have right now has indicated, as Ms. Todd was describing, a willingness to allow states to experiment and to perhaps chart their own course. You're absolutely right, and another administration could come in and reverse those policies. But right now is a window for courageous states and states who are willing to experiment with some of these new ideas to show that they can work. to show that they can work and to establish that the sky didn't fall, the crime rates didn't go up, that in fact tax revenues that were generated helped to offset some of the awful fiscal crises that are facing all of the states right now, and so that a new administration might think twice where its political views may change as it sees a good example put into place that will work.
I'm sorry, just to follow up on the previous question too.
Sure.
Can the state tax or fee a substance that the federal government says is illegal to do? Can we legally do that even? And would that part of it, the actual money part of it, be addressed as well in the federal courts, and would that hold up? And let's say we decriminalize, we're not legalizing it, because I don't know if we could actually physically legalize it if it's still illegal on the federal side, but we decriminalize our penal code sections. Can we tax an illegal act? I mean, in the federal eyes, that kind of thing. Does that still work?
Sure. I think that, and I'm not a tax expert, but my understanding of the constitutional principles that I've been talking about would still apply, right? So the federal government can't prohibit the state from changing its own laws and imposing a fine or a fee or a tax for activity that the federal government says is illegal. The federal government can still come in and enforce its own laws. But can the state charge a fee at the front end for the sale of an ounce of marijuana? I don't see any difference between the state doing that and what the state currently does, which is fine some of the people who have an ounce of marijuana $100 after the fact, after they're caught. So it's still the state's getting money, right, from activity and profiting from activity that the federal government has prohibited. And the only other point, I guess, that occurs to me along those lines are the tax stamps that some states have applied, so that there are already a couple of states, I believe, that do charge a tax for activity that the federal government has said is illegal.
Yeah, and
we wouldn't have a worry about self-incrimination at all?
Oh, no, I'm sorry. I did mean to respond to that point as well. Yeah. Again, that in my mind is one of the sort of nuts and bolts. How will this be implemented? An implementation question, because certainly as long as federal law remains what it is, anyone who says on a form that they file with the state of California that they've been engaging in this activity is incriminating themselves for federal purposes. And I guess what I would say is that yes, federal government can still investigate and use its resources to try to get that information and prosecute people. But we have, again, right now an indication from this administration that it doesn't intend to do that with the same intensity and vehemence that we've seen in the past.
Let me, I'm sorry, you're through. Let me jump in. We want to give Mr. Mayor's been very patient an opportunity. Thank you, Mr. Hopper. There may be further questions.
Sure.
Mr. Mayor, thank you so much for your patience. And
thank you, Mr. Chairman. My name is Martin Mayer. I'm General Counsel for the California Peace Officers Association, which is an association consisting of approximately 4,000 law enforcement officers of all ranks in the state of California. I also serve as General Counsel for the California Police Chiefs Association, which consists of virtually all municipal chiefs of police in the state of California, and I'm here to speak on behalf of those two associations. I agree with virtually everything that my colleagues said, and I guess I could almost stop at that point, except there are a couple of areas with which I have to take exception. In all candor, truly, virtually everything that Ms. Todd and Mr. Hopper said, I concur with completely. The only area with which I have to respectfully disagree and find somewhat surprising is the statement that the difference between legalization and decriminalization is confusing. It's not. It's not confusing at all. In fact, what I would submit to you is that you really do need to change what you're talking about. The state of California cannot, unequivocally, cannot legalize marijuana. That is not a statement coming from me. That's a statement coming from the California Supreme Court. In the decision of Ross versus Raging Wire Telecommunications, Inc., the California Supreme Court, in addressing whether or not the state of California could even legalize marijuana for medical use, stated, quote, no state could completely legalize marijuana for medical purposes because the drug remains illegal under federal law, even for medical users. Instead of attempting the impossible, as we shall explain, California's voters merely exempted medical users and their primary caregivers from criminal liability under 2 specifically designated state statutes, close quote. That, ladies and gentlemen, is the difference between legalization and decriminalization. Proposition 215 is not, in my opinion, unconstitutional, nor does it conflict with the Controlled Substances Act. Reference was made to the San Diego versus Normal case. I concur with the decision in the San Diego versus Normal case, because what the court ruled was that the mandate that a county issue an ID card didn't violate federal law, and it doesn't violate federal law. The only thing the ID card does is substitute, if you will, for my little CVS prescription bottle. I carry with me heart medication in a little container. It's categorically illegal, and I could be arrested for the possession of my heart medication because the law says it has to be in a prescription bottle. Well, you can't have a prescription for marijuana, even for medical purposes, because it violates federal law, and that is an unequivocal statement of fact. And doctors know if they write script for marijuana, they can be prosecuted and probably will be prosecuted and had been warned that they could be prosecuted. Advising on the use of marijuana, however, is protected speech for the doctors, but writing prescriptions would be illegal. So our law, Proposition 215, talks about a recommendation, not a prescription. As a result, when the law was passed and Senate Bill 420 included the mandate, and it is a mandate on counties to have a program to issue ID cards, what the court in the San Diego versus Normal case said was all that does is identify that I am one of those who are exempt from criminal prosecution for the possession, use, transfer of marijuana for medical purposes because I am either a qualified patient or I'm a legal primary caregiver.
Let me jump in. Couldn't the court then use the same analysis for marijuana legalization?
Sure. Yeah. The state of California absolutely categorically can decide to not criminally prosecute people for the possession of marijuana. That does not legalize it. As the California Supreme Court said, you cannot legalize it. No state can legalize it. All the state can choose to do is not prosecuted under state law. And Mr. Hagman, you are absolutely correct that the federal government can and still possesses the authority to prosecute anybody in the state of California for any amount of marijuana in his or her possession, and it is only a policy decision that was expressed by the Attorney General based upon resources. He explicitly said they are not going to expend federal resources to prosecute those people who are lawfully under state law in possession of medical marijuana, but that's a policy decision. That doesn't change the reality. It's still illegal. There are district attorneys, and I believe Ms. Harris in San Francisco was one who, when she was first elected, said she wasn't going to be prosecuting cases involving consensual prostitution. That's a prosecutorial discretionary act. She has the absolute right to do that. And Mr. Holder has the right to decide whether or not he will prosecute certain types of cases.
And then with that line of thinking, then the state could also remove criminal penalties.
Absolutely, as state penalties. But until or unless Congress chooses to change the law, the possession, the use, the transportation, the transfer of marijuana, the cultivation of marijuana is a felony until or unless Congress chooses to change it. And so far, quite candidly, it has consistently refused to do it. It has even consistently refused to merely change the level of enforcement. There have been a number of proposals to Congress to recommend that those states that have adopted medical marijuana laws not be the target. And it's only now under the Obama administration that the Department of Justice, not Congress, has made the decision to take a different approach in those jurisdictions.
Yeah, and I do know that there are a few Congressman Barney Frank has some legislation that, if it's enacted, I think would address it.
And if they change the law, they change the law. But until then, it's illegal in the state of California to possess or use marijuana.
Your testimony seems to say that if it is legalized, the feds could still arrest people.
And again, with all due respect, sir, I think it's misleading to the public to refer to the legalization of marijuana in California, because it's going to mislead them into believing that it is now lawful to possess it.
I think we're capable of dealing with the semantics, but yeah, I think we also have to be aware of what the general parlance is in people's minds. I mean, you can move people away from something, but if you don't convey it in terms that at least they can grasp, you're also doing them a disservice.
The cross I bear is I'm an attorney, and I have to deal with law.
But if the state, exactly. I mean, in fact, if we had to guess what your vocation was, it would be an easy one.
It's on my name tag.
But would a state statute legalizing marijuana then be invalidated?
I'm sorry. Say again, sir.
Okay, so your testimony saying, well, if it's not legal, then the feds can still arrest.
Absolutely.
But then, would that make a state statute legalizing, would that make it invalid?
If you tried to pass a state statute to legalize, and again, I'm not playing semantics, that would be, in my opinion, invalid. If you chose, on the other hand, to have a state statute that removes from the penal code and from the health and safety code penalties for the possession and use under state law, that's perfectly valid. You can do that.
Hagman, and then Mr. Hopper.
Thank you, Mr. Chairman. Again, so I'm going back to semantics here, and I'm kind of bring these things up to get different points of view on the same issue. So you can't make it legal.
Correct.
I think that would, for my rudimentary law too, would probably get struck down.
Right.
Just because it does come in absolute conflict, I believe, with the federal current law. I think also, I heard reports today that the Deputy Attorney General says we're not relaxing issuance of marijuana as of today. So it's conflicting with the Attorney General that said last week. I mean, this administration can move back and forth, which I also think is something for us to keep in mind as political pressures going one way or the other up there. Policy and enforcement policies do tend to change out of administrations, not only federal level, but state level and county and local levels as well. Again, going back to the self-incrimination, I think that is something that I still don't feel comfortable with. If we decriminalized our stuff, but we put some kind of rules and regulations, which we'd have to in order to tax and fee it, and bring revenues to state, local agencies, you're going to create a record of some sort.
I agree.
And I would believe some person, when some federal agency comes in and receives those records, are going to come after either us as the body that legalized it, or after the federal say, you can't force me to self-incriminate myself in order to purchase the stuff that you're saying now I want to tax or fee.
That was Al Capone's argument. They got him.
It's so I'm still trying to figure out and maybe we have another group of panels that would say practically how you can do that. I don't see us actually doing that, and therefore raising any kind of revenues from this I think is kind of wishful thinking if we can't enforce that policy in order to tax or fee it. So I just want to have some kind of comments on that.
I would have to agree with you completely, Mr. Hagman. I believe that a prosecutor most assuredly could use the fact that someone paid a tax on the purchase of marijuana to be able to prove that they purchased marijuana, in the same way that if we established a tax on houses of prostitution but still said running a house of prostitution is unlawful, but you shall pay tax if you do, which you can do, by the way. You can tax illegal activity. That is how they got Capone, because he didn't pay the tax on the illegal activity. So if I ran a house of prostitution and I paid the tax, the fact that I paid the tax could be used against me to show that I engaged in illegal activity, and it would be a form of self-incrimination. The option would be for me not to pay the tax.
Well, now that we've introduced prostitution into the hearing, Mr. Hooper.
If I could just for a moment, these words are so pernicious. Making it legal. I agree completely with Mr. Mayor that there's nothing that California can do to legalize marijuana under federal law. There's nothing that California can do in a statute that changes what federal government's prerogative to enforce its own laws. Absolutely right. But that is not the same thing as saying that California can the only thing that California could do is remove existing laws from its own books. The California legislature can create its own laws, making legal or illegal under state law any activity it wishes. The distinction in Ross v. Raging Wire was that an employer had fired someone, and the person said, wait, this violates my rights under the state anti-discrimination statutes. And the employer said, well, no, you were engaging in illegal activity, and there's an exemption in the anti-discrimination statute for employees who engage in illegal activity. And the employee said, well, it's not illegal under state law. And the court said, well, the statute doesn't say state or federal law. It says that if you engage in illegal activity, you engaged in activity that's illegal under federal law. Okay. California can't change that.
All right.
So,
no, with respect, Mr. Chairman, I just need a moment.
Just a moment, sir.
Just a moment. Yeah. But there's two on that side and only one on this side. So if I could just have a moment.
Look at who the one is, Mr. Mayor.
Thank you.
All right. But we do have a time limit.
I understand.
I don't want to
It's not my interpretation. I'm directly quoting from the California Supreme Court decision in Ross, and when they made the reference to the legalization, it wasn't in terms of the FEHA law, it was in terms of the claim by Ross that using a prescription drug would prevent them from discriminating against him, and the court said the plaintiff's position might have merit if the Compassionate Use Act gave marijuana the same status as any legal prescription drug. But the Act's effect is not so broad. No state law could completely legalize marijuana.
Okay. Thank you.
Thank you.
Any questions from the panel? So we want to move on to our next one. All right. Why don't you give it a shot? Okay.
My understanding, too, and even currently with our current medical marijuana law, and I want to see how you address this, is from the studies I've seen in L.A., and obviously L.A. County, L.A. City is doing an aggressive campaign against the shops now that provide it. From talking to prosecutors over there, they have done FDA testing on the substance itself. And it's just like the one thing of everything we produce that we consume that's not regulated by FDA at this point. And some of those testings came back that obviously showed that this product was imported from different parts of the world, presumably South America, since different pesticides are used up here, they're illegal up here, and it was tested there. How do you address those type of things too when it's not tested, and it could have, I mean, I guess the levels of carcinogens in there were 900 times the ingestible limit. How do you propose to, if we're able to decriminalize it somewhat here, not make it legal, but decriminalize it, put the quality controls on that so we're not poisoning our people who are using this stuff too? And also violate another law by importing it from out of the country indoor to the United States.
Yeah. Okay. If we could just be brief, and there'll be further panels where we could explore this.
I think that will be gone into in some of the further panels, but I think that goes directly to the need for why people are calling for regulation and a system where you make it legal, you establish some regulations so that there can be more control, quality assurance, more ability to control who has access, where the marijuana comes from, what the substance actually is, whether it's adulterated, is better dealt with through a regulatory system than the black market.
All right. All right, listen, thank you. Fascinating. I really appreciate your
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you very much.
All right, the next panel, the effect of legalization of marijuana on the criminal justice system. We have Mr. Talinan, former district attorney of City and County of San Francisco, Dan McAleer, executive director of the Center on Juvenile and Criminal Justice, Sarah Simpson, acting assistant chief, Office of the Attorney General, Bureau of Narcotics Enforcement, John Standish, president of the California Police Officers Association, and Ms. Mannheimer, who is the incoming president of the California Police Chiefs and Associations, sends her regrets. She cannot be here today. Welcome, everyone. Mr. Standish, I'm looking right at you, so why don't you begin?
Thank you, Mr. Chairman and members of the committee. The California Peace Officers Association, or otherwise known as CPOA, is comprised of 4,000 members of chiefs, sheriffs, executive command staff, managers, supervisors, and some line officers in the municipal, state, and federal law enforcement agencies that operate in California. I want to thank the committee for an opportunity to speak to you about this issue, and I'd like to frame it in the focus of 2 questions, and I have several points to address these questions, and we believe all of these points touch our California criminal justice system, what the men and women on the streets deal with every day. When we look at an issue that would have a substantial impact on society, we must ask ourselves 2 questions. 1, will this issue protect and promote society? And 2, do the positives outweigh the negatives? There is no way that marijuana could protect or promote our society. In fact, it radically diminishes it. The following points contain information regarding marijuana facts, medical information, and the economic impact of marijuana use and the results of other countries which have tried and failed in the legalization of marijuana. First, the basics. Marijuana is a mind-altering addictive drug. Marijuana robs you of memory, motivation, and concentration. Short-term effects of marijuana use include memory loss, distorted perception, trouble with thinking, problem-solving, and anxiety. Children with an average grade of D or below were more than 4 times as likely to have used marijuana in the past year as children who reported an average grade of an A. A single marijuana cigarette or joint is composed of more than 400 different chemicals, not including all the pesticides, all of them toxic. On combination...
Can I jump in here? And yeah. I don't mean to be rude, and perhaps you weren't here in the beginning of the hearing, but I do appreciate your testimony on this and your point of view, but in terms of physiological and health effects, that was not part of our discussion today, not because we're not going to do it, but because we felt it would be more appropriate we don't have any doctors here today, we don't have any of that kind of testimony, because we felt we do have a committee on health aspects, and that's where that would be heard. So if I could respectfully ask you to abandon that and continue. And okay. I really don't mean to be rude about that. I'm sorry if you didn't understand.
I will just, I'll skip on to the economic impact in the criminal justice system. Several studies, I'm talking about economics right now, several studies link workers who abuse marijuana with increased abstinence, tardiness, accidents, workers' compensation claims, and job turnover. Proponents claim that we could tax marijuana sales to help our economy. They conveniently forget that although alcohol and cigarettes are taxed to the hilt, the taxes gathered do not cover the cost of the imposed medical treatment, let alone the price of DUI or driving under the influence, fatalities, accidents, and the injuries from those accidents. The decriminalization of marijuana would lead to an increase in crime rates, an increase in social costs, an increase in medical costs, which we won't talk about, a decrease in the labor force, and an increase in environmental concerns. And in the eyes of the California law enforcement, this is one of the most critical areas, and I'm sure other people are going to talk about this, so I'll be very brief. There is a very real concern that the Mexican drug cartels are behind most of the imported marijuana coming into the United States. This is a huge concern due to the drug war, murders, and rampant kidnappings that are taking place behind these drug sales. There's a real concern regarding the medical side effects on smokers who use the marijuana coming from Mexico because of the toxic pesticides. Other countries' efforts and failures. In the Netherlands, they legalized marijuana in the form of marijuana cafes. This led to a 49% increase in registered cannabis addicts between 1991 and 1993. In 1998, there were 3 organized crime groups in the Netherlands or Amsterdam. By 1993, there were 93 organized crime groups. Shootings increased 4%, car thefts increased 6%, and robberies increased by 69%. Cannabis use among students in Holland has increased by 250%. The Netherlands gained the reputation of the crime capital of Europe in 1990. In December 2008, Amsterdam unveiled plans to close brothels and marijuana cafes in a major effort to drive organized crime out. The measure will start with 36 marijuana cafes being closed, a little less than 20% of the city total. This will cost them $38 to $51 million to restore the area. The argument that legalization will mean that addicts will no longer have to commit crimes in order to obtain money for the drugs was put to the test in the 1960s in Sweden. During that time, the Swedish government decided to medicalize their drug problem. However, an evaluation of the legal prescription of narcotics in Sweden demonstrated criminality increased despite the fact that narcotics was freely available, or cannabis. The British Medical Association voiced extreme concern that merely downgrading the criminal status of marijuana would mislead the public into believing that the drug is safe. Their government did not heed the Medical Association's warning and downgraded cannabis from a Class B to a Class C in 2004. This resulted in an increase of crime and various health problems. In May of 2008, they reversed their decision and reclassified it back to a Class B. Thank you.
Thank you so much. I'd like to get your take on, there's been so much attention and resources on marijuana enforcement, camp, and other gestures. We still have very high methamphetamine use, other kinds of harder drugs that plague our communities. Do you think it would be a better use of our resources to fight meth instead of marijuana?
That's like, when did you stop beating your wife? No. I think marijuana is a gateway drug. I'm in my 30th year as a police officer in the state of California, and every incident that I have come upon where marijuana has been involved in it has not been good. I don't think it would be right to, say, stop focusing on the enforcement of marijuana, let's focus on meth. I think they're both equally critical problems that our society needs to address.
I didn't want to present you with that kind of conundrum, but okay. I just wanted your experience take on what you thought of that. That's
Mr. Chair, after, like I said, 30 years involved in law enforcement in California, I have seen nothing good come of this.
All right, sir. I really appreciate your testimony.
Thank you.
Thank you. All right. Could we hear from Ms. Simpson?
Yes. Good morning, Mr. Chairman and members of the Public Safety Committee. I appreciate the opportunity to appear before you today and provide a statement on this topic. I'm here to provide technical assistance related to the Bureau of Narcotic Enforcement's experience in marijuana eradication. This would include our understanding of the role and subsequent violence attributed to the drug trafficking organizations that are illegally operating in California for the purposes of cultivating and distributing marijuana among other controlled substances for financial gain and furtherance of the criminal organization. In addition, I will provide funding considerations that specifically affect marijuana eradication on state lands, which include federal funding that will not be redirected to prevention, treatment, or other law enforcement services. Throughout the 26-year history of the Office of the Attorney General's Bureau of Narcotic Enforcement, the Campaign Against Marijuana Planting Program, also known as CAMP, has experienced an increase in large-scale marijuana grows. There has been a significant increase in Mexican drug trafficking organizations, also known as Mexican DTOs. The Mexican DTOs have taken over many of these large-scale grow operations, as was the trend with methamphetamine manufacturing, distribution, and sales in the early 1990s. These current operations are set up in remote areas in order to avoid detection from law enforcement. Currently, the trends remain the same. The majority of the large-scale grows are operated by Mexican DTOs, and they continue to conduct their operations in remote areas of the state of California on both public and private lands. The 2009 camp season documented 76% of the seized gardens were on public lands that occupy large areas within the state of California. Many of the hazards with investigating these operations include the sophistication of the organizations. Typically, the workforce is recruited from civilians with close ties to the Republic of Mexico, and they are supplied with weapons, surveillance equipment, booby traps, and escape routes. The National Drug Threat Assessment for 2009, released by the National Drug Intelligence Center, states that Mexican drug trafficking organizations operate in more than 230 cities across the United States. These Mexican DTOs not only smuggle drugs through the U.S.-Mexico border, but they also produce drugs here in our country, specifically California. Their domestically produced products include methamphetamine as well as marijuana. Mexican DTOs' extensive use of public lands for marijuana cultivation is increasing, even in areas that are generally not considered conducive to planting and growing marijuana. Mexican DTOs commonly grow marijuana in remote areas of public lands where there is limited law enforcement presence. The occurrence of marijuana cultivation on public lands has increased significantly over the past several years, largely as a result of increased domestic cultivation operations by Mexican DTOs. In 2009 marijuana season, Camp exceeded all projections and eradicated an all-time record of 4.4 million plants. Approximately 3.3 million, or 76% of these plants, were on public lands. In that same year, Camp dismantled 659 gardens, processed 1,581 pounds of marijuana, seized 86 weapons, and arrested 86 suspects. In comparison, 1.6 million plants were eradicated in fiscal year 2006-2007, and 2.9 million plants were eradicated in fiscal year 2007-2008. That's a 127% increase. Another legislative consideration includes the large-scale grow operations that are using public lands resources for cultivation. Large-scale marijuana cultivation leads to deforestation, damage to wildlife habitats, and can cause hazardous chemical pollution. Oftentimes, the diversion of water to irrigate marijuana grows harms nearby ecosystems, including creeks, streams, and rivers. The National Park Service estimates that for every acre of forest that is planted with marijuana, it results in 10 acres of damage from pesticides, chemical repellents, and poisons that are used in an attempt to increase productivity of the garden. It costs approximately $11,000 per acre to restore the damage to public land caused by these gardens. We could simply revisit the devastation that occurred in the 1990s as a result of rural clandestine methamphetamine labs in California as a reference. Also impactful to potential legislation would be the regulation of THC levels, which is the active ingredient in marijuana. In 2006, law enforcement reporting from several different agencies revealed that some Mexican DTOs were achieving an 8 to 12% THC level by augmenting growing methods typically used by indoor growers of high-potency marijuana. This was a drastic spike from the previous 2 to 3% THC levels which were yielded from outdoor grow operations previously. This high-potency marijuana produced from outdoor plants in California is often comparable to the quality to Canadian-produced BC bud and commands twice the price of commercial-grade Mexican marijuana. Currently, there is a supply and demand for higher potency marijuana, and legislation will have to establish legal THC levels and then consider how to best prepare for the high-potency black market marijuana cultivated and distributed by Mexican DTOs. Anticipated legislation should also be beholden to the safety of our citizens. California's current statutes relative to marijuana cultivation allow for criminal justice system to work proactively in investigating, dismantling, disrupting criminal organizations, oftentimes before the situation becomes violent. The National Drug Threat Assessment for 2009 concluded by stating, and I quote, "Mexican DTOs represent the greatest organized crime threat to the United States. The violence, intimidation, theft, and financial crimes carried out by DTOs, criminal groups, gangs, and drug users in the U.S. pose a significant threat to our nation. In forecasting future trends, we believe that regulating marijuana will have little effect on criminal DTOs that are already operating for profit in California by cultivating high-potency marijuana. We believe that just as our marijuana laws have been ignored by these DTOs, so will the regulations. Additionally, we expect continued violence and may even experience a spike in violence due to turf wars over marijuana garden land as well as suppliers. And now I'd like to share a few documented incidences of associated violence that should be considered during the legislative process. September 2000, El Dorado County. William Hunt and his 8-year-old son Matthew were shot while hunting on their own property. Both victims were shot in the face with a shotgun fired by a Mexican national guarding a marijuana crop. September 2003. Shasta County. Shasta County deputies shot and killed 2 armed men who were guarding a large marijuana grow in the national forest. One subject was armed with an assault rifle and the other a handgun. The garden contained 35,000 marijuana plants. August 2005, Santa Clara County. A walk-in team was ambushed by armed subjects in a marijuana grow in a regional park near a populated area. A California Department of Fish and Game officer was shot and wounded. Officers returned fire and killed one of the suspects while the other suspect fled. 22,468 plants were seized. October 2005, Shasta County. During the investigation of a Mexican DTO grow operation, a confidential informant tells investigators that the growers are heavily armed and said they will not be taken alive. The growers told the confidential informant that they will shoot it out with the police. During the raid of the grow, an AKA-type assault weapon was recovered by officers. October 2006, Mendocino County. 2 members of the Round Valley tribe were discovered killed, execution style, near a large marijuana grow site. Information received was that the murders were attributed to Mexican nationals and a dispute over turf, and the stealing of 5,000 marijuana plants. October 2007, Humboldt County. 2 deputies were led by a private timber company security officer to an area that was believed to be an abandoned marijuana grow. The garden had already been harvested and the marijuana was drying. The 2 deputies went to the area and encountered an armed Mexican male adult who raised a shotgun at one of the deputies. The deputy fired and killed the armed Mexican male adult. Further investigation by the FBI revealed that the decedent had been identified as being involved in homicides in Mexico. The decedent was in this country illegally from Mexico. 983 marijuana plants were seized. 2008, Santa Clara County. Deputies encountered an armed subject while walking into a marijuana grow site. The suspect took an offensive stance with his weapon and was fired on by deputies. The suspect was killed. 39,174 plants were seized from South Bay Regional Park.
If I may jump in, and thank you so much for your presentation and your statistics. I think the question for me is, if marijuana were legalized, wouldn't the resources, if you can go to a place and purchase it that's licensed, wouldn't there be a decrease in this kind of violence? It's not so much that the violence, it seems to me, is occurring because someone's under the influence, so to speak, of marijuana, but because of the nature of these cartels and the illegality and, of course, the scale of it. And let me just tag on something. If, in fact, we did legalize marijuana, what then would be the relationship of your organization? Because I know you work closely with the feds, so is that too much at once?
Yes, it's a bit of a complex question. Yes, let me explain it to you this way, though. Right now, you have Mexican drug trafficking organizations that are operating in this country, and they're completely ignoring the laws that we have on the books as we stand right now. No regulation is going to make them step up to the plate and now say, okay, well, we're going to play by the rules. Our fear in this is that a couple of things. It's kind of two-part. One, that these Mexican DTOs are going to take over the trade on marijuana because they're going to have such extreme THC levels, and that's what people, the people that are there to get high, that's what those people are going to be looking for. The second portion of this is a funding issue with the federal government. We do receive a significant amount of money from the federal government for the campaign against marijuana planting. We anticipate that some of that funding would go away because that is going to be redirected to states that actually have aggressive marijuana laws.
You know, my take on this is that if there were regulation, and I have heard from many people who are interested in this issue and do use marijuana, that well, I'm not going to use the language they use, but it's too potent, it's too powerful. That's not what they were looking for. So I mean, within the user population, I think you have various desires as to how high you want to get, and one of the criticisms has been that the stuff is too potent, and they would rather, if it is licensed, have it regulated so that it wasn't, you know, very, very, very strong. I mean, because it's kind of a give and take about who uses it and what they like and where they would go for it. That's all, you know. So,
sir, can I just add just one statement?
Sure.
I think we're chasing shadows here. I think we're all going to be extremely naive thinking that the organized crime elements are just going to say, okay, fine, we'll just go do something else. They're going to increase their efforts, they will adapt, they will find more loopholes in our system, and they will still be there causing problems.
Yeah, it sounds like our corporate world, that, you know, I mean, it's interesting. But what I want to ask, though, wouldn't you know, and I'm the layman here, you know, you're the guy with the 30 years experience, is wouldn't the legalization and the regulation of it allow more law enforcement to be focused as these people, as you surmise, would be trying to work the system?
It's an interesting question and a spirited debate, but we can't legalize it.
All right, very good. Listen, Ms. Simpson, if you're through and there's no questions, in interest of time, okay, Mr. Hagman, and then we'll go to our short.
Want to let the rest of the panel speak and do their statements first?
All right, why don't we do that? Okay. Okay, thank you so much, Ms. Simpson.
You're welcome.
Okay, Mr. Malakari?
McAleer.
McAleer.
I got it. Thank you, Mr. Chairman. My name is Dan McAleer. I'm the Executive Director of the Center on Juvenile and Criminal Justice. We're a non-profit, nonpartisan organization based in San Francisco. We examine various issues of criminal justice on the criminal justice field, both juvenile and adult. I think the reason I'm here is I was asked to conduct an analysis of arrest statistics surrounding marijuana within the greater context of the drug war, what's generically called the drug war in California. When we started doing this, and as I said, we do these analysis and studies periodically on a variety of issues. A couple months ago, I called my lead researcher, Mike Males, who's a PhD from UC Irvine, and I asked him to take a look at arrest statistics specific to marijuana in the state of California. And he said, okay, and let me get back to you. He calls me back in a couple of days, and he says, I think you need to look at these numbers. I think they're quite shocking. Because when you look at the arrest statistics, what it does is it reveals something of a contradiction, or at least it maybe reframes images that we currently have about the drug war in California. One, the drug war in 2009 is not being focused or concentrated on manufacturers and sellers. In fact, the drug war in California, and specifically marijuana, and particularly marijuana, is being focused on the drug users, which I think comes as a surprise to a lot of people. And I'm not making this up. These are the statistics that are put out by our own state departments. These are based on official statistics. And I'll just give you an example. The biggest rise, in fact, let me rephrase that. Virtually every category of crime in the since 1990 we've seen dramatic declines in. The one category that we looked at that showed not a decline but a dramatic increase in arrests was marijuana possession. Now, marijuana possession is an ounce or less. So it's what we call relatively a minor offense. It's a misdemeanor offense. But yet we seem to be devoting more and more resources to focusing on making these low-level arrests. So just to give you a couple of numbers, I know I don't want to overburden you. It's in our report that's been distributed. In 1990, there were 20,834 arrests for marijuana possession, simple marijuana possession. In 2008, there were 61,388. It's a 127% increase. Now, in the area of possession of arrest for possession of all other drugs combined, during that time period, there was a 29% decrease. So the higher level drugs, such as methamphetamines and cocaine and heroin and those drugs, we've actually apparently have de-emphasized that in favor of marijuana arrests. Felony sale, manufacture of marijuana, a 21% decrease. That's, again, manufactured sales, decrease in the amount of arrests. Felony sale, manufacture of all of the drugs, negative 33%. So we're actually down. There's actually less enforcement, and you can reach your own judgment on that. But the irony here is that we seem to be focused more and more law enforcement resources on the arrest of marijuana users. Now, again, in that context, the other thing that was interesting in this study is what it reveals about the drug war in California. When you think about a drug war, you think of some kind of centrally located, focused initiative statewide. That's not what we have. We have a patchwork of priorities. It's county based. So you have wide disparities from one county to the next. And it's not just a blue state or a blue county, red county divide. It's an interesting picture. You have some counties that we quote would probably classify as liberal, Santa Cruz County, Merced County, perhaps more conservative, and yet they have very high levels of marijuana arrests, where you have other counties such as Contra Costa County or San Francisco County, very low rates of marijuana possession arrests. It's all over the board. There is no continuity. There's no consistency.
What about the demographic? Is there any consistency in that?
Well, that's again, it reveals another interesting picture. The demographics, meaning divided by age groups in the arrests. What you see is a preponderance of the arrests occur the 21 and under age group, at least on the marijuana arrest area. But what you have is an interesting dynamic occurring, and it's again a change from historical patterns. Is now that we see a growing increase in the number of over 40 people being arrested, primarily African American, but also European people of European American descent. But it's an over 40 age group, and so you have that interesting divide. It's the 21 and over. First of all, again, these are low-level marijuana possessions, and then you have the 40 and over. I guess the question it raises is this the best use of our dwindling law enforcement resources? Do we want to be focused on increasing low-level marijuana arrests at the time when as I said, all other offenses are in decline? And there's one argument that would be made, I assume it would come up, is, well, isn't this a way to reduce crime across the board? You start low and you reduce the higher-level crimes. And the answer is unequivocally no. First of all, the research is pretty clear on that doesn't happen. But just in this case specifically, counties that had very low levels of, quote, marijuana enforcement also experienced dramatic declines in their crime rates overall. And you see it, and you see this across the board. In some counties had increases when they were taking a strict approach to enforcing marijuana laws. So it was a patchwork. There's contradictions, there's inconsistencies, but there's huge disparities. What we have here is we have a patchwork of laws that are being enforced in some counties and not being enforced in others, or counties are simply taking, I think the voters have stated, at least with medical marijuana and Prop 36, is that Californians prefer a more treatment-oriented approach.
I was going to ask you, if marijuana were legalized, what kind of significant reform would be needed? The context of it, and I think you were just broaching.
Well, if marijuana were legalized, first of all, I think that some of the points that were brought up, and I think some of the legitimate points that I agree with, or the points that I agree with, is that it would allow us to better concentrate our dwindling law enforcement resources towards a more serious problem. And frankly, I consider methamphetamine, cocaine, heroin more serious drug problem than marijuana, and I think most experts will come down on that in that area. So I think that in terms of how to better deploy our law enforcement resources, it's not towards making low-level marijuana arrests. Thank you.
Mr. Hallinan, welcome.
Thank you, Mr. Chairman. Still getting used to not calling you a fellow supervisor here. I think that there's no question that marijuana alleviates the pain and suffering of some people, and significantly does so. And we have no desire, nor I think would it be possible for us to repeal Proposition 215 or to do away with medical marijuana. It's in fact something we're understanding more about all the time. So the issue is, how do we reconcile the widespread use of marijuana with the legal policies that are attached to it? And I'm assuming that's what you're trying to work out here, and it's certainly a major question for law enforcement, because part of our present policies are that it first creates a vast underground of illegal activity, of individuals participating in things which are against the law. Marijuana, much marijuana is brought into the United States. That involves smugglers, sailors, pilots, and a whole distribution network for it, all of whom are violating the law. Much of it is grown in the United States, as we've been pointing out here, and I've had cases of this. They talk about the Mexican mafia. Many of the cases I have involve Mexican Americans, but I don't know that it's a Mexican mafia, but nonetheless, it certainly involves growers. It involves a whole sales network, buyers, sellers, and so on. Not only does this create a vast illegal underground, but it leads to widespread violence, because part of the illegality and the money that is involved in it leads to people committing illegal acts. Many people arm themselves in this industry because of the fact that there are people who are armed who are stealing marijuana. There are these terrible home invasion burglaries with brutality and loss of life. It has created a whole level of illegality and violence. And it's a violence that in the process of it leads to police corruption as well. It has not had a good effect on law enforcement. When these raids take place, there's money laying around. I have yet to have a client who had a considerable amount of money who didn't at least contend that some of the money was taken, that there was less money than they had had, or that the money had disappeared. And I feel that there's just too much temptation to put in the way of police officers, many of whom don't make a lot of money and are looking for it. It's a temptation for corruption that we'd be much better off without. And in addition, it's a temptation for these police officers to cheat on the affidavits and the documents they file showing probable cause to make an arrest. Those things are not good for anybody. It wastes vast police time and resources. In San Francisco, we estimate that 70% of our cases in the district attorney's office are drugs, and that a third of that 70% have to do with marijuana. We talk about the minor citations for possession of marijuana. Well, they have to go somewhere. Something has to be done to them. They have to appear before a judicial body. And
yeah, a jury. I mean,
well, I was going to say there is a whole vast, but there is a whole vast other area of people who are growing it. Cultivation is a serious felony, carrying 16, 2 or 3 years in state prison. It involves sales. Sales are not legal anywhere, but we know that, in fact, there's over 1 million people in California who've used marijuana, and there's only a few thousand who've signed up or registered for it. So there are many people, and many of those people are people whose pain and suffering are alleviated by the use of marijuana, whether they bother to get a doctor's recommendation or a card or not. The police department devotes a tremendous amount of resources to this, because these are not necessarily easy arrests to make. That is, they can go out on the street and see somebody making a sale. They can make arrests that way. But if they want to, for example, obtain a warrant and go in and have and seize a crop that is being grown in a house or something, that's a whole different situation that involves warrants, lots of time, going to court. It really does try up our courts and our jails to a great extent. There are thousands of people who indirectly, if not directly, are in jail for marijuana offenses in California. And I certainly hope that this committee can find some way in which we can reconcile the situation with marijuana with the legal situation that exists. I mean, I'm proud to have voted Obama, and I'm so happy that he had the courage to finally say this is a state's issue. It's up to California to work this out, and I think we should take advantage of that and work out a policy that other states can follow, and eventually we will see overcome the whole United States.
Mr. Hallinan. Mr. Hagman, do you have a question for?
Thank you, Mr. Chairman. Yeah, I do have several questions and a lot of different takes. I've been involved with public safety probably for 22 years and couldn't see opposite in some of these things. I do believe that going after lower offenders does stop. At least my portion of my exposure to it is when we catch someone. Oh, first of all, let's go over some of the numbers on the arrest, and anybody can jump in on all these things. You say we have a number of arrests for marijuana possession stuff. I can't know too many counties that actually put you in custody for that. Generally, it's a diversion program, a fine, and that's it. So what percentage of these arrests that we're looking at the tables here, can anyone answer, are actually of that of possession, the smaller infractions, misdemeanors versus the felonies, basically?
If I can answer. Most of these do not lead to jail or imprisonment. The point is that California is devoting more of its law enforcement resource, this is a reflection of it, towards the possession end, towards the demand side. And it runs counter to a lot of recent voter initiatives. Also, as I said, we reached a milestone in 2008. For the very first time, prison commitments, prison admissions in 2008 for possession exceeded the number of prison admissions for sales and manufacturing. That's the first time in history.
Well, let me follow up on that logic here, if I can. From what I've seen in my field experiences, it's become more of a organized type of crime effort. So you're going to have less people growing in the backyards and more of a centralized thing. And generally, most of the arrests or most of the things we deal with are not just possession alone. It's always we were catching them in the act of a burglary, and they had a possession on top. So are these statistics distinctive of multiple charges, or are they strictly, these are, when you do arrest for possession, are they strictly for possession, or are they also because, how many people are getting pulled over and say, I'm searching you right now for possession? No, they don't. They usually get pulled over or arrested for an act of another crime. And how many of those crimes are predicated for trying to serve their habit of use, and how much are drug related in general? And those are the things that it's hard with statistics when you start playing around the numbers to find out how they coordinate or not.
Assemblyman, if I could respond, and I don't disagree. That point may be true. At times, certainly people are pulled over for other crimes, and they're in possession of marijuana. That will not show up in the statistic because if they are arrested, as you know, as a law enforcement person, if they are arrested for a more serious crime, they'll be charged with a more serious crime. This is a misdemeanor offense, possession,
That's why I'm wondering
less than an
statistics.
ounce.
Are they strictly the misdemeanor possession infraction charges to not a list of charges, and one of them happen to be an infraction charge?
It's a reflection of the arrest for the most serious charge. So that's
okay.
I don't think anybody should believe that we do not have marijuana arrests in the state of California anymore. We just issue citations and it's it, because our courtrooms are full every day with people who are cultivating. That's a straight felony. You have to prove that you're not cultivating. How many plants are there? It's a complicated process. Homes are still being lost. It's against the law to make a sale even of a gram or a tiny amount of marijuana without the person's medical card, although, so there are lots of people in court and there are lots of people in jail, I know in San Francisco, for marijuana offenses.
No question about that. Moving on back, we have a medical marijuana law now, and we're seeing how it's been rolled out. And I think there's been some issues on that, how local entities deal with the statute, because it's not very clear how it's supposed to be implemented. And there's some that are very liberal on it as far as setting up the co-ops and stuff, and others that are prosecuting these dispensaries because the law is very specific on how it's supposed to be regulated, who get business licenses. I know the fact that was brought up for I think the city attorney of LA, there's more dispensaries now than there are Starbucks in the city of LA, which is hard for me to believe that many people have that medical need for that. But what have you seen with the statistics, going back to the numbers? Have we decreased some of these violent. If you do the correlation that if you legalize marijuana, you may have less violence because you have the less legal activity of selling, transportation, growing, and stuff like that, and legally selling it through a dispensary type of thing. Have we seen any numbers switch in the counties that have embraced this Medical Marijuana Act to the fullest, like in maybe other areas, and the ones who have not? Have we seen any change in statistics at all? Does anyone have any impressions on that?
If I could respond, the answer is we have crime declines throughout California. Crime has declined in counties such as Alameda County and San Francisco County that take a very less harsh approach towards marijuana enforcement. So there is no connection between harsh drug law enforcement, or in this case, marijuana enforcement, and crime rates. We've been down through this. We've been down this road many times on a number of other issues too. Crime is down across the state. It's down across the country. States that have harsh laws, states that don't have harsh laws, and in California we have 58 counties. And as we see, counties take a vastly different approach. So I think it calls for reform. I think if the way we interpret the laws is that they're evenly applied, fairly, and it's not a function of what county you happen to be in. My argument for reform is that, to be fair, it should be uniform. It should, you shouldn't have to be in San Francisco County to lessen your likelihood of facing arrest for marijuana possession than if you were in Butte County or some place
Again,
like that.
I want to make it clear, marijuana is not legal in California. Police officers do not turn their backs on marijuana in California. I practice in San Francisco every day, and every day there are marijuana cases in the courts in San Francisco. Cultivation is not legal. Sales or giving away marijuana is not legal. So many things that there are thousands of people in San Francisco County who run into law enforcement problems as a result of their use or growth of marijuana, and we shouldn't deceive ourselves that it's just a matter of ironing out some little problems. We have a big problem between the people the few thousand who do comply with the law on medical marijuana. I commend them. I think it's a great progressive thing the state of California has done. But there also are thousands, hundreds of thousands of people who don't comply with that law, but are not criminals, are not people who would under any circumstances be out violating the law, other than they might use marijuana. They might not have a doctor's recommendation. They could get that doctor's recommendation.
All right. Thank you very much. And in the interest of time, we do have to move on. And I want to thank you all for your presentations and points of view, and bring up our next panel, and then we're going to have public comment.
Thank you, Mr. Chair.
Thank you, Mr.
Well, thank you, Mr. Chairman, and this is really a courageous, wonderful thing you're doing, and I commend you for it.
Thank you, sir. That was not a paid political announcement. Okay. I want to thank everyone for their cooperation. This is our last panel before public comment. The legalization of marijuana and effective drug policy. We have Reverend Mary Moreno Richardson, Reverend of the St. Paul's Episcopal Cathedral, Jim Gray, retired judge, Orange County Superior Court, Dale Geringer, Executive Director of California NORML, Scott Kirkland, Chair, California Police Chiefs Association's Task Force, Rosalie Pacula, Co-Director, Drug Policy Research Center, RAND Corporation, and Ms. Simpson, again, from the Attorney General's Bureau of Narcotics Enforcement. And maybe we could start with Reverend Moreno.
Thank you.
And,
good afternoon.
We're going to try to keep to our schedule. I think we've been doing very, very well. I know that these are complicated issues, but I think we're all learning a lot. But we're going to try to do this in the allotted time. So,
Great. Good afternoon, Mr. Chairman and State Committee. I'm the Reverend Canon Mary Moreno Richardson. I'm priest in charge of Latino ministry at St. Paul's Cathedral in San Diego and the director of the Guadalupe Art Program, which addresses violence against women and children. I serve in San Diego as a chaplain to victims of human trafficking and incarcerated undocumented youth. I also have served as a chaplain at Central Juvenile Hall in East Los Angeles and as a mental health clinician at the Violence Intervention Program for Los Angeles County, USC. And I have also worked as a case manager, community educator, and I am a certified chemical dependency specialist and have facilitated court-mandated classes as drug diversion, DUI, and domestic violence. I have worked for over 22 years in the field of addiction in Santa Barbara, Los Angeles, and San Diego County. I also want to state that I have with me an email from Rabbi Jeffrey Kahn, Executive Director of the Interfaith Drug Policy Initiative, and he would like me to tell you that he writes and he says, I am honored to join you and other clergy working to stop this awful war on people and family, masquerading as a war on drugs. And I also have from the Interfaith Drug Policy Initiative, which is a national organization from the United States, on their support of decriminalizing marijuana. And those churches include the National Council of Churches, United Methodist Church, the United Church of Christ, Presbyterian Church, the Unitarian Church, and also Central Conference of American Rabbis and the Union for Reform Judaism and the Episcopal Church. I would like to tell you a little bit of the work that I have done and what I have noticed. I have also want to address the issue of medical marijuana and how I have seen the benefits of very many people who suffer from chronic pain, whether it's HIV or if it's cancer. As a priest, I have to do pastoral care, and I have seen the benefits of medical marijuana with a lot of these people. Unfortunately, my mother, who's a senior citizen who suffers from chronic daily pain, refuses to even have the conversation with me because she's so insulted by the question of using medical marijuana. And I think that has to do a lot with how society has demonized marijuana, and this is what we're living with. I have also worked, one of the stories I wanted to tell you that I used to facilitate the domestic violence classes for Santa Barbara County. And I would do a little survey of my own. This was a class of probably 15 persons, usually men, who had assaulted their partners. And I would ask them two questions. I would say, how many of you were under the influence of alcohol when you beat your partner? And out of 15 persons, at least 13 hands would go up. And then I would say, I have another question for you. I said, I want to know how many of you were under the influence of only marijuana when you beat your partner. And it was so amazing to see the responses. Most of them looked at me like I was crazy to even ask such a question. They even told me that. The question does not make sense. Why would I even get off the couch to hit my wife? So, I mean, this is just something that I would see over and over again. And this is what I would see. And I think it's very important to bring up today because alcohol is a legal drug, as we know. And yet we know that on Super Bowl Sunday, that is the day that there are more assaults against mostly women in domestic violence cases. I would also like to talk to you about my experience with children in juvenile hall. Mostly the children who've been taken away from their families and put into foster care because their parents were arrested for marijuana offenses. Many of these kids, as young as 8 years old, are incarcerated in our jails and wind up incarcerated themselves. This is intergenerational, and it is also coming from our communities of color. When I was in juvenile hall, 95% of the children incarcerated are children of color. I believe that this also talks to the trust that children have with law enforcement. When I was growing up, I trusted the police. I went to them when I had a problem. Nowadays, children run from the police. They just do not have that trust anymore. I think that we also have to address that there's so many children that, when you have a group of kids that are together on the street and maybe one of them has a joint, they'll take the whole group in. They will arrest the whole group. And we know that in juvenile hall, children do not have bail. So those children have to sit in jail and wait to see a judge and tell them, I had no idea that this person had a joint on him. So I think that we also see, while those children are incarcerated, that for their own safety, they end up joining gangs. And what I've also seen is that over and over again, jails have become the boot camps for gangs. So what I think we can improve with our marijuana, regulating marijuana, young people would have a harder time buying marijuana. Right now, it is easier for them to buy marijuana than alcohol or cigarettes because, as the judge always says, dealers do not ask for IDs. And I think it's really important on this issue that we need to think about our youth and protect our youth. Our youth are not protected right now. If I walk across to the park right now, I will not be offered, someone will not come up to me and see if they can sell marijuana to me. But if a 15-year-old goes across the street, they probably have a much better chance of being approached.
So what I'm gathering is that you're suggesting that the effect on the community and families is not a productive one.
Right.
And particularly minority families, which is...
Particularly minority families, and we also see that there's a huge crisis in our foster care system because of all the children who have been taken away from their parents because of marijuana offenses. Okay? All right, sure. And I just think that we need to take responsibility for the human family, and I really believe that we are called to take care, to really stop the discrimination against the community of color. And I think one of the questions I have is, what have we learned from Prohibition? Thank you.
Mr. Hagman, I believe, has a question
Thank
for
you. Just two quick ones. One, Reverend Richardson, you're a certified drug specialist, right? You dealt with the youth. Are you advocating that it's okay for there to be that influence, or in your programs, don't you teach them to get off the substance abuse, right, in any substance abuse?
I'm not working right now as a substance abuse counselor. What I brought to this table today was just my experience of when I have...
You and I advocate. You would advocate for people to not... As part of the... When you release people from juvenile hall, they have to go through that training to get off drugs, right?
No, there is. You know that in LA County there's only about 5 different detention centers, juvenile halls, and maybe 1 treatment program for minors. So that's the other issue, too. We don't have treatment for minors.
Okay. Secondly, you said that by regulating that the youth may be able to go across the street to the park and buy marijuana. Do you think by us regulating or putting it in the stores legally, that underground market would go away?
I believe...
And what evidence would you have to base any of that? I mean, it was still a market that would be sold to.
Well, I do think, but I think with regulating, as we see with cigarettes and alcohol, it's much easier for our kids today to get marijuana anywhere, mostly from their friends at school, in many areas where they're not able to get or to buy alcohol or cigarettes, but they can buy marijuana.
Okay. All right, Mr. Kirkland and Ms. Fairchild, do you want to tag team? Okay, Mr. Kirkland.
Good morning, Chairman Amiano and Vice Chairman Hagman. My name is Scott Kirkland. I'm the police chief in the city of El Cerrito. I'm on the board of directors for the California Police Chiefs Association as well as the California Peace Officers Association. Moreover, I am currently the chairperson of the California Police Chiefs Medical Marijuana Task Force. The task force is comprised of representatives from the California Peace Officers Association, California Police Chiefs Association, California State Sheriff's Association, California District Attorneys Association, California Narcotics Officers Association, and any other interested parties. The issue of marijuana has taken on prominence not seen before. Decisions that will impact our lives are being decided by popular vote and party lines when the full body of knowledge is not being provided to the public. This is the first substance that is being touted as medicine that's worth as such is not being decided by the normal regulatory rules established by the likes of FDA. People in responsible positions are voting on this issue believing that marijuana is the same substance that they might have tried in the 60s, 70s, 80s, and the start of the 90s. If they did not try it, they knew someone who did and did not see the unintended consequences. But let us look at the plant itself. Marijuana is a plant that for centuries was unaltered. It grew in the wild. When the crude plant started to become popular in the 1960s, it was still considered wild. The plant was comprised of about 50% THC, the psychoactive ingredient, and 50% cannabinoids. The THC concentration was anywhere from 1 to 3%. With the popularization of the Canadian grow methods and the passage of the state initiative, the crude plant changed dramatically. No longer was the plant wild, but was grown in controlled environments. The crude plant was altered genetically, and a majority of the cannabinoids were eliminated. The plant today averages between 18 to 24% THC content. There have been plants that have been found to have THC concentrations in the low 30s. But the scientific research that is being conducted on the plant throughout the world is showing that the cannabinoids are the beneficial part of the plant, the part of the plant that has been bred out in terms of the current growing processes. The crude plant is now nothing more than a THC breeding machine. The advocates of this issue have once again selected a very well-crafted message to the public. In essence, they are saying that if the state of California should legalize and tax the marijuana, that this action would allow the state to remain solvent. The argument would then be that with a solvent state, police officers, firefighters, and teachers would not be laid off. The Board of Equalization states that there would be a possible $1.4 billion in new tax revenues available. I have concerns about the legitimacy of their assertions and the underlying facts used as its basis. In May of 2009, the National Center on Addiction and Substance Abuse at Columbia University released a report entitled Shoveling Up Part 2, The Impact of Substance Abuse on Federal, State, and Local Budgets. This 176-page report documents for the first time the cost of the two legal substances that are abused today, alcohol and tobacco. The costs are substantial. In 2005, the state of California spent $19.9 billion on substance abuse and addiction, or $545 per capita, based on a population of 36.5 million. Once again, I'm talking specifically about alcohol and tobacco. But the state of California collected $1.4 billion of tax revenue, or $38.69 per capita, on the sale of alcohol and tobacco products. Yes, the cost far exceeded the revenues. On June 19th of this year, California's Carcinogen Identification Committee of the Office of Environmental Health and Assessment Science Advisory Board issued a ruling that listed marijuana smoke as a carcinogenic. If we are to examine this issue in the vacuum of monetary impact alone, why would we, residents of California, want to legalize a crude substance that is known to cause cancer when the cost of substance abuse of the psychoactive drug will far outweigh...
Chief, excuse me, with all due respect, I want to be even-handed here because we did correct another speaker. At this hearing, we're not going to discuss the health benefits or detriments. We're going to hold that over for our health committee, and I'm sorry if you didn't understand that, and I just wanted to point that out to you since I already pointed it out to someone else. But thank you for your accommodation.
I can go on?
Oh, yes.
Thank you. A crime we are seeing an increase is drug driving. Even without marijuana legalization, this is a serious problem. A 2004 study of emergency room admissions for motor vehicle crashes revealed that more than half of the drivers admitted to a level 1 trauma center tested positive for drugs other than alcohol. This study, published in the Traffic Injury Review, was similar to numerous other studies. Significantly, when breakouts were done of the drugs that resulted in the driving under the influence accident and or arrest, the overwhelming majority of test samples showed marijuana in the blood system of the arrestee. Legalization of marijuana will only result in an increased use of marijuana, with a corresponding increase in drug driving arrest. Unlike many countries in Western Europe and over 12 states in the United States who provide that the presence of any level of illegal drug in a person's system is a driving violation, California has no statutory system in place to deter drug driving. In fact, I brought forward a bill that was sponsored by then Assemblyperson Benoit to address this serious issue, and this committee rejected the legislation in 2008. Drug driving is a serious growing problem, and marijuana is a major element of drug driving. Law enforcement has no real tools to combat drug driving, and surely no one in this room could seriously suggest that legalization of marijuana will help with this problem. You are entrusted to make policy decisions that are in the best interests of all Californians, not just special interests and or advocacy groups. This is a serious issue, and a couple hours of testimony will not afford anyone the ability to present research, scientific evidence that would shed enormous light on this psychoactive drug. Thank you.
Thank you, Chief. We do appreciate your presence here. And just a small correction, as author of this legislation, have mentioned that their taxation could be a benefit in terms of income for the state, but in no way did I ever state that this would solve our budget problem, if only. If only. But thank you. Ms. Fairchild?
Thank you. Good morning, Mr. Chairman and Vice Chairman of the Public Safety Committee. I appreciate the opportunity to appear before you today to discuss the important issue regarding legalization of marijuana.